Thank you, Mr. Thomas. It seemed quite hot in here when we just came in. I've turned it down. Well, it was down as low as possible. Let's only hope it's made a slight difference moving the dial. I doubt it.
Thank you. I think for those behind it may be more than us, but thank you for that. Just in response to my learned friend's intervention just before lunch, whether it's relevant or not, the court will note from the skeleton that was served at trial. I'll give you the reference. I'll read it. C 386, tab 86. It was said below. It's also worth noting the delivery of the cargo to those vessels at anchorage C at Sohar was a breach of the terms of the bill of lading contract, which required discharge to take place at Fujairah. So, for what it's worth, as far as relevant to the point my own friend made, that was their case at trial, at least, to the preceding case on which we proceeded. In any event, I was making my submissions to the court on the first ground of respondent's notice. I perceive some judicial headwind on our submissions in relation to the novation, but if I may just summarise our position, and then I'll move on to the third limb. What we say is that at the time of that agreement, both the parties contemplated BP's sole role in future would be as the bill of lading holder, and so the consent to discharge in future in that document can plainly only have been by BP in that capacity. And we submit that had BP required owners to perform bill of lading obligations strictly, i.e. only against the production of bill of lading, it's inexplicable they'd have agreed to the terms of the novation. So that's our position on the novation and the effect of it for the purposes of this part of the respondent's notice. The third aspect we submit that is relevant is that BP were kept informed of what was going on, and they neither objected or intervened when they were notified by owners that they were about to discharge the finance cargo at Sohar at a time when BP knew that the bill of lading remained in its possession. They didn't raise any complaint.
Sorry, could you just say that again?
BP, my lord, it's...
Sorry, I just didn't. I want to get it down.
Indeed. They did not object or intervene when notified by owners that they were about to discharge the cargo at Sohar at a time when BP knew that the bill of lading remained in its possession and therefore couldn't be used to obtain discharge, nor did they raise any complaint when notified that all the finance cargo had been discharged. Now, the details of those communications are set out in our skeleton argument, which I hope will be a convenient reference point for the court. And I'd say this wasn't simply a one-off. So it's a post-novation, and I don't think we need to go to every one of these.
Paragraph number of your skeleton?
14, my lord, I apologise. If I might just show you some of the documents, many of them are in the same format, but by way of example, we have at tab 36 of the supplementary bundle the ETA at Sohar being advised to, amongst others, BP. That's page 107, tab 36. Tab 39, page 110, the notice of readiness is sent to BP as well.
Why was it being sent to BP?
Well, it can only be sent to BP in this context as bill of lading holders we submit.
And because it might have some effect on demurrage liabilities under a contract on the terms of the bill of lading.
Under the terms of the bill of lading, my lord.
Yeah, well, yes, bill of lading holder, but why would the bill of lading holder be interested in receiving an NOR?
But it's been kept abreast of what's going on. The vessel's arrived. Here's the NOR, and as well, subsequently, it's sent information about what's going on with discharge. So it's been kept abreast of all the events.
But why? In your case, it's not interested in the kind of contract of carriage at all.
Well, my lord, the position we submit is that we're sending the bill of lading holder on this hypothesis being informed of what's going on, and as I've said, it takes no objection. It knows the position, it has the bill of lading, and it's not objecting to discharge without that bill of lading.
I'm not suggesting you did anything wrong. I'm suggesting that the reason might have been because it's relevant to the contract of carriage that existed with BP as the bill of lading holder by this stage.
But if that's right, then it is received by BP as a bill of lading holder.
Well, I agree. It may help you on this aspect of the argument, but not on the earlier aspect.
Oh, well, there's always yin and the yang in these cases, my lord. It's
no, but it's a genuine inquiry. Why would BP be interested in receiving the NOR other than for the purposes of rights and obligations under the bill of lading contract, such as in relation to demurrage in particular?
well, obviously, in our submission, the objective analysis of whether there is a contract in place, I mean, the bill of lading is in their hands, and it may well be that they were kept abreast because they putative holders the bill of lading, and owners are not necessarily inquiring in their own heads whether that is actually a contract of carriage at this stage or not. But on this assumption, and on the assumption advanced that the bill of lading is a contract of carriage, we submit that these were plainly sent to them as holder of that bill. And what the court will see, and again, I don't think we need to go to all of these, but in the references in paragraph 14, just to take, for instance, one example, tab 41, BP are being sent details of the discharge operations. I think most, if not all of those documents, say for the last one, which is a port time log, are in the same sort of format. So what you'll see is a series of documents in a similar format providing details of what's going on at the discharge ports, the fact that the cargo is being discharged, and so on. And that applies to the references both in respect of the Cutch Bay and the Prestigious. And as I've submitted, we say objectively these communications were to BP not as charterer and can only be as holder of the bill of lading, such that at the time when the bill was in the possession of BP, they knew it couldn't be presented, it was being notified, and it raised no objection. And that we submit is consent for which we contend. In our submission, when one looks back at the synthesis in the STI Orchard, which I took the court to, we have precisely the sort of consent referred to in that case. We submit that there is clearly communicated express consent, at least in the form of the novation, which would fall within subparagraph A of paragraph 70, or at least in our submission acquiescence by PP in a form from which one can assume or presume the assent to the release of the goods. And that's point made in subparagraph B, and also in the main grain case, but as the Voyage Charters extract explained, silence can be acquiescence in certain circumstances, and that's an alternative submission. So in our submission, when one looks at that, and although I do sense some resistance in the report, when one looks at it analytically, that's exactly what we find. Bill of lading holder is sent all this information, it knows the position, and it doesn't intervene or object or complain, and that is, we submit consent to discharge in those circumstances. So that's the basis of our contention.
If you're right about that, that would apply in many cases. Of course, it's not inevitable that the bill of lading holder will know exactly what the status of the voyage is, but he will usually know that whilst he's holding the bill, discharge has taken place without it, if it does take place without it.
My Lord,
You say all those cases he knows, and then, unless he actually intervenes and says don't, that's acquiescence, and he loses his right to.
that's part of our submission, my Lord, yes.
I'm just exploring quite how wide-ranging it is. It is, I think, something which would be available in many, many cases.
My Lord, I don't think we can shrink from that part of our submission. But my Lord, there's a number of objections raised. I think many of them are Aunt Sally's. The nub, I think, of the point that I need to address with the court is the point that's raised that this is only a waiver. Sorry, this can only be analysed as a waiver, and that the waiver can't bind subsequent transferring of the bill. Now, taking that in stages, we don't accept that the only analysis here is that of waiver, and I've taken you to the various authorities. In our submission, there are other ways of analysing it. But in terms of the point about waiver, my learned friend didn't address this orally, but referred briefly, as he does in his skeleton, to a passage in Aikins. Now, that point, if we just reference it for the court, it's in their skeleton at page 203 of the bundle, tab 15, paragraph 42, I believe. And it simply states a waiver of a right under the bill of lading contract is not binding upon any subsequent holder of the bill. Now, I just ask you to note how that's, but a waiver of a right under a bill of lading contract is not binding upon any subsequent holder. And the authority is the reference to Aikins and Bools. That is tab 23 of the authorities bundle, page 320. And the court, I think, may have already read this, but if I just invite the court to note that the question, it said the question arose in Titan, Tate and Lyle. The ship was chartered to load at 3 ports. She deviated before the charterer loaded cargo at the 3rd port. The vessel then suffered a casualty and incurred general average expenditure. When the cargo that was saved arrived at discharge port, the bill of lading was presented by the holder in ignorance of the deviation. Questions whether the presenter of the bill of lading was liable for freight and liable to pay general average. It was argued that the holder of the bill was bound by their terms and was bound by the charterer's waiver of deviation following loading of the cargo at the 3rd port. The House of Lords held that Dorsey was not bound or affected by the waiver. So that's the brief summary. If we go to the case, in our submission, it doesn't stand for as wide a proposition as appears to be relied upon. The case is at tab 3, oops, tab 2.
No.
Oh, I'm sorry. Tab 4 of the authorities bundle.
Yes.
Third time lucky from my perspective. And in our submission, the starting point is that this is not a misdelivery case. The appellant has identified no other case, and certainly not one where claim for misdelivery has been brought by a subsequent holder where this has been taken or observed to allow it to do so. And on the contrary, we'll come to the UU, which is relied upon by the bank in due course, but we will suggest that indicates that there's no claim in such a situation. But in reverting to this case, in our submission, on an analysis, it dealt with a different position, different case. The first point is that it concerned a post-breach waiver in that charterers waived the breach by subsequently electing to treat the charter party as subsisting. Now, it's a little bit difficult to pin that down in the judgment, but in our submission that does appear to be the case. In particular, on page 62, there's the paragraph at the top of the page, about halfway down. It's stated, in the present case where the charter procured the ship to be recalled to a San Domingo port for the express purpose of continuing to load under the charter, an obligation which of course existed in pursuance of the express contract, and saw that the ship did receive the cargo stipulated under the subcharter, provided the person had no right to load except under the charter. I'm satisfied that there is abundantly conclusive evidence to justify the report of Ransom J that the deviation was waived by charterers. So as I said, the waiver appears to have been willingness of charterers to continue with the charter party, but it was an ex post facto waiver. And we do submit that on this hypothesis that we're addressing, we're concerned here not with the question of breach, waiver of breach ex post facto, but actions by PP consenting to discharge, i.e. creating a position where there's no breach in the first place. It's a waiver of the need to perform that part of the obligation. The second point we submit in relation to this case, it's not clear, certainly not suggested in the judgment, that there's any wider waiver. Say, for instance, a waiver of the right to claim damages for the breach. Obviously, choosing to, electing to continue the charter party or a contract you could otherwise rescind isn't the same as waiving your right to damages. And thirdly, in our submission, when one turns to page 62, bottom of 62, and on to 63, what the court says is this: in respect of the first, in my opinion, the fact of the deviation gives the bill of lading holder the rights I've already mentioned. On discovery, he's entitled to refuse to be bound by the contract. Waiver by the charterer seems on principle to have no bearing upon the rights and liabilities which devolve upon the bill of lading holder under the Bill of Lading Act. The consignee has not assigned to him the obligations under the charter party. So what, in our submission, the court is saying is that waiver of rights under the charter party doesn't bind somebody who's a party to a different contract, i.e. the Bill of Lading contract. And in our submission, that is, or the proposition for which this case stands is no wider than that. So it isn't relevant to the position we have, assuming or otherwise with me, that there is a waiver by the Bill of Lading holder of rights under the Bill of Lading contract. So that's why...
Is this a case of subsequent endorsement, subsequent to the deviation?
Your Lordship's question is when was the bill endorsed over?
Yes.
My learned friend believes... No. Well, maybe we can check that and come back to you on that issue.
Because if it was post the breach and waiver, so that it was the charterer who was the bill of lading holder at the time that took place, then that would seem to suggest that by reference to your respondent's notice point 1, that doing something qua charterer can't amount to waiver of the bill of lading contract.
Well, I apologise, I can't answer your question. I think I read it and wasn't sure it was in the judgment. We will reread it.
Well, I can look as well. But
certainly, my lord. So I apologise if I'm unable to assist you. But we do submit that this case, for the reasons I've given, doesn't assist in the scenario.
But you say it's not authoritative the proposition that waiver can't bind someone in the future.
Right.
Here it's reliant on the fact that there are two different contracts that are being talked about.
Indeed. And indeed, we submit that would be a surprising conclusion. If the lawful holder could expressly authorise discharge and the later holder says not bound, that would be odd. What we submit is the proper analysis. In that circumstance, the subsequent holder would have a claim against the original holder under whatever transaction they may be party to. So that would be the avenue of recourse. The other authority which may bear on this point is the UU, which is in tab 14. Now, the facts are complicated. I don't think we need to look at them for the purposes of the passage that I'm going to take the court to. But there is a section of the judgment at page 244 of the bundle, and it's paragraphs 66 to 67. There's a discussion of the position where the cargo is delivered to the party entitled under the bill, and proposition for which we submit this stands is that if delivery is made to a person entitled to delivery under the bill, even without production, there's no claim for misdelivery by a subsequent transferee. We say so for the following reasons. Just to try and explain the question to which the court is addressing its mind, in paragraph 66, two questions are posed, and it might just ask the court to read that paragraph itself. Those are the questions the court was considering. As we'll see in paragraph 67, it then said, with regard to the first group of questions, the premise that delivery to a person entitled under the bill of lading necessarily involves surrender of the full set of bill is incorrect, and he then addresses various different scenarios. In paragraph 69, he takes up and makes the point that the bill of lading would be spent by delivery to a person entitled to delivery under the bill of lading, even if the delivery was made without the carrier citing the bill. Whilst the carrier may be acting negligently in breach of contract with the carrier for delivering without citing the bill, whether the bill is spent depends on whether delivery was made to the right person, and not whether the carrier knew that he had delivered to the right person. Thus, delivery to the right person would cause the bill to be spent even though the carrier has not ascertained whether the person receiving delivery was the person entitled. And he goes on just below that to indicate that an obiter dictum in the future express, which if the court wants to see it, is in paragraph 65b, i.e. the view that delivery to a person entitled under a bill of lading would not exhaust the bill if it's made against an LOI without surrender of billing was wrong. So that's certainly the view expressed by this court, and in line with a number of authors cited. And then at 72, we can pick it up. It says, as for the second group of questions, paragraph 66, the answer is that even in a case where there's no misdelivery, there could still be contractual rights of suit to transfer for damage to cargo, short delivery, and so forth. So we submit that what one sees here, and we do accept that it may be implicit rather than explicit, but that those passages in our submission support the argument that Tate and Lyle waiver wouldn't apply in any event to spent bill situation where the bill becomes spent prior to the transferee obtaining rights. So that in our submission is another strand to this particular argument, but principally in terms of the case relied upon to support this principle, as we've seen, we've been through it and we submit it deals with a different situation, and beyond that the bank produced no authority to support its case in this regard.
I'm sorry, you've completely lost me. It's my fault because I haven't read this before. So,
my lord, I do apologise, and I appreciate
the question of whether a bill is spent, at least since the 1992 Act, may be of significance in relation to whether, as a document of title, it has any use. But it doesn't have any relevance, does it, to rights of suit because of the express provisions of Section 2.2. Is that right?
correct.
So there is quite a lot of learning, which obviously this touches on, as to when bills do or don't become spent. But is that relevant to us for the purposes of a claim under Section 2?
Well, in our submission, it as I say, implicitly supports the notion that in the circumstances in question, there's no claim for misdelivery if it's been delivered to the right party, which is the hypothesis here which we're developing. And maybe I'm overcomplicating the situation.
That's directly contrary to the cases like the Hooder, which say there is a breach even if you deliver it to the right party without the bill. Whether there's loss is a separate question, but the obligation is to deliver against the bill. There's no answer to say I'm the right party.
Well,
am I mischaracterising what was said in the Hooder?
Well, no, my lord, in that context, no. The Hooder, although isn't, well, it comes back to the debate we had earlier about the point of transfer, maybe, and what rights are transferred, and it feeds back to that. Maybe I'm overcomplicating the issue on this, the position on this issue, because in our submission there's no support for the notion of the waiver, and it seems in our submission at least that the bank has to show you why there would be no waiver.
And you introduced it as authority of the proposition that if there's delivery to the person who's entitled to delivery, there can't be any claim for misdelivery by the subsequent grant.
I hope I didn't say that. I
may have misheard you.
I hope as it was implicit in the case that there wouldn't be a claim for misdelivery in those circumstances, except it's certainly not the ratio of the case. It's part of a discussion in a wider context.
Well, if that is what is implicit in it, it's directly contrary to the Hooder, isn't it?
And I think you take that from paragraph 72, don't you? No.
I might move on then to the respondent's notice, ground 2, which is the bank caused its own loss. It is common ground between the judge didn't deal with this argument in her judgment, and it's obviously different to but related to the causation argument that we've discussed. Now, in our submission, the bank says, oh well, this amounts to no more than because it agreed to the finance, it caused its own loss. Now, we say that isn't the correct characterisation of our case. The position here is, of course, the bank on this hypothesis was not the holder of the bill of lading at the time, and it said on a number of occasions it had no entitlement to instruct via Gulf or otherwise owners to discharge or deliver the finance cargo, and therefore they had no entitlement to act in the way it did. And that's the essence of our case in this regard. If it did so, then it was effectively interfering with the rights of BP under the bill of lading as lawful holder. And so that's the difference, and that's why we submit it isn't the case that my learned friend says it is. Ultimately, This is a matter which the court.
Sorry, and I'm being very slow this afternoon. Could you just tell me what your case is, not why it isn't what Mr. Russell said it was? What is your case on bank causing its own loss? How did it do so?
Well, in this hypothesis, it was not the lawful holder of the bill of lading, and at the time of discharge, it had no entitlement to instruct via Gulf or otherwise owners to discharge or deliver the finance cargo, which is what it did on the facts, and on its own case that was not the lawful bill of lading holder, it had no entitlement to do that. In effect, it was usurping BP's rights under the bill of lading, and if it hadn't required Gulf to arrange discharge without a bill of lading, it's the position that wouldn't have taken place.
So it's meddling.
Yes. In developing that case, my lady, I'm not sure I can do much more than refer to the way it's set out in our skeleton argument in the appeal. I think both sides have been prepared to leave it with the written submissions, so we'd ask you to take those into account. As we say, the primary case which we advocate is that ground 2 causation is absolutely right, and if we write on that, then there's no need to look at this alternative, but we leave the position on ground 2 of the respondent's notice with the way it's set out in our written submissions. Now, in relation to ground 3, this is a question which my learned friend dealt with, I think, quite briefly. I do want to just explain the position.
So I'm sorry to keep holding you up, but could you just identify where in the skeleton it's dealt with, so I can just have a look as we go along?
This particular ground?
Your point 2.
Point 2, your Lordship will find that in our skeleton at page 181, paragraph 74 to 83. Just on the third ground, then, if I may, this is a question I think ultimately devolves down to whether, if you're against us on everything else, this and other questions should be remitted to the judge. Now, the dispute is as narrow as that in our submission, although my learned friend sets out in his skeleton submissions on the merits, and we, if you like, prophylactically have done so in response in our submission. This court cannot deal with that issue of fact on this appeal. So it's a question of remission. My learned friend says, oh, you made an application to amend which was refused, therefore you can't run this. Now, that is not the position as accurately described. As I'll show you, what happened is that an application was made, it was refused, but that was on the basis of a case advanced by the bank, which then changed at trial. And at trial, issues were raised, the objections were raised, and both parties had their say. The court didn't determine, in light of everything else that was decided, whether or not this matter should go forward and how it should go forward. But the starting point to try and give the court just a flavour of where we are at or where we reach.
So I keep interrupting you, but I'm having difficulty getting things clear in my mind. The argument that you either could or couldn't run was that delivery took place to the people who were in fact entitled to delivery.
That's the issue which
That's the issue.
yeah.
Well, it isn't one answer. So what? If the breach that's relied upon is a breach in delivering otherwise than against a bill of lading, which is a breach whether or not you deliver to the right person.
Well, that's why I highlighted to the court the position under paragraph 36 of the reply and subsequently in 64, where, as we said, we'd understood it to be accepted that if it was delivered with the authorisation of the bank, there was a defence. So there is that related point which arises on this.
Suppose that's wrong. What's the answer as a matter of substance?
So, sorry, if that argument's wrong.
Yes. What's
Then
the answer as a matter of substance to the point I'm putting to you?
Sorry, my lord. The matter of substance being.
Am I right in saying that the Hooder tells us it doesn't matter for the purposes of a breach that you deliver to the right people if you do it otherwise than against the original bill of lading? If that's what the Hooder says, this point doesn't matter.
Well, my lord, we submit it does, because it's a question of obviously whether the Hooder makes the point that if you deliver to people to whom it's authorised, there may be no loss in any event. That's one aspect, but also it comes back to this question of consent and so forth.
Just take it in stages. No loss. That's obviously in the context there being spoken of parties claiming that they should have had the cargo delivered to them but haven't. That's the loss that's there being contemplated, not the loss of a security interest by a party holding a security interest. And how does it affect that loss?
Because if in fact it was delivered to the sub-buyers as authorised by the bank, then their loss isn't caused by the alleged breach.
Well, it's no different from if the normal case of delivery against an LOI to the people who happen to be entitled to it, where the bank has a security interest and the people who happen to be entitled to it don't pay.
Well, my lord, I think the same response would be that the causation aspect would apply here too.
I mean, you'd have your no loss point
Indeed.
on ground 2 of the appeal in any event. I quite understand that. I don't understand what this is adding to it, other than a point I think you seem to get out of what might be described as a pleading point, saying, aha, they agreed that it would be an answer, therefore it must be an answer.
Well, my lord, maybe on reflection, that's what the court decides. It said on the grounds of appeal, it's an issue that we submit ought to go back for, if you do find against it and everything else, go back for consideration to see actually what the court concluded and then to draw the relevant consequences from it.
But that would be odd. If we took the view that it's not an issue which can affect the result, I'm not really sure whether there's any basis on which I could be persuaded anyway to say we should send it back to decide something that's immaterial.
From what I accepted, that fact of the view you formed, as I've said, at trial we submit an issue, and it was, our understanding at least, accepted that if that was the case, it was delivered with authority, aka the NICA, etc., then there would be no claim for. Now, my learned friend disputed that interpretation, I accept, but that was the point that was raised by it. And so that's the context in which it arose. And certainly, I hear what your lordship says. You may consider actually, on reflection, there's no conceivable relevant issue here. But subject to that, then we submit it is one that ought to go back to the judge if we lose on all the other aspects. The court.
So can I then just write down so that I get it right? Why you say it is a relevant issue? If delivery was to receivers, which were those authorised by the bank, then acquiescence. Is that where the argument goes?
Authority as well, the NICA analysis.
And authority. And here focusing on the conduct of the bank rather than the conduct of BP, who were the holder at the time.
Yes, and NICA was a financing bank case as well. When looks at it, it was a similar situation.
So it's acquiescence or authority by someone who is not, doesn't yet have an interest under the bill.
Yes, Mum.
Thank you.
So that's how it arises, and then the spat between us, I think, is summarised in the respective skeleton arguments in response to the point that's made that actually the earlier decision refusing leave to amend is definitive. We disagree with that for reasons we summarise particularly in our supplementary skeleton. If I might just outline them rather than go through that in detail, what the court will see is in the list of issues, this is raised and is identified as a relevant issue. For instance, issue 4.5 is the finance cargo is delivered to the sub-buyers, and the question is, does that give rise to a defence in those circumstances? So it was an issue in the agreed list of issues.
But then that's caveated.
Of course.
In the list of issues.
Of course.
Which you weren't going to take us to by saying the bank says it's not open to the owners.
So I apologise, but it was addressed as an issue, potential issue of fact for the tribunal, for the court. And as I was going to come to...
Right, but you've premised what you're saying by saying you disagree that the refusal of leave to amend was not fatal, and you're telling us why, and you said you could do it without, for the reasons given in your skeleton, which you didn't need to take us to, and by reference to it being an issue in issue 4
my Lord,
5.
I was trying to hurry
that
through.
issue itself
I
recognised that it might be fatal.
I apologise.
But there hadn't been leave to amend.
My Lord, the position in that regard is as set out in a supplementary skeleton, and maybe it's sensible for me to take you to it, albeit briefly. It's tab 16 of the core bundle. For your note, it's paragraphs 8 through to 11. And maybe the simplest thing is for me just to ask the court briefly to read that section of the skeleton to understand the context in which we say the matter was still open for decision by the court. So, my Lord, I'm not sure I can take it any further than that. We do say that, say, a new positive case was introduced. It was a matter of debate before the court as to whether that was open to either side. And subject to your Lordship's point about the legal relevance, that's a matter that should go back to be determined if we get to that stage. So I apologise for mischaracterising the list of issues. But I hope that's been of some assistance, unless there are any further points which I can assist.
I'm obviously losing it this afternoon. Where in paragraphs 8 to 11 of your skeleton does it address why leave to amend is not fatal? Am I looking at the right?
I hope, my Lord, that you are. Are you in the supplemental skeleton?
No, I'm not.
Sorry, my Lord.
No, well, that explains it. My fault. 8 to 11. Would you just give me a moment to catch up? I'm so sorry.
Of course, I apologise, my Lord.
Fantastic, thank you. My apologies.
I've thankfully finished well within, I think, the time anticipated. So unless I can assist you any further, those are the comments from Hill.
Thank you very much indeed, Mr. Thomas. Mr. Russell?
Griffin. Lady. If it's convenient to the court, what I propose doing is looking at the second ground of appeal first, so the causation issue, first of all. Then look at the bill of lading issues, the first ground of appeal. And then perhaps say a very few words in relation to the respondent's notice grounds. I don't mean to be, in any sense, to be disrespectful to the learned judge. The learned friend said that in our scale of an argument, we can't point to a paragraph of the judgment on causation in which we can illustrate that there was an error of law. And as I say, without any disrespect to the judge, that is because there is simply a lack of legal analysis of any sort in that part of the judgment. And what the judge has done is to make factual findings, albeit on a hypothetical case or counterfactual case. Those factual findings being at paragraph 61 that the bank would have been involved. It's paragraph 61 of the judgment, which is at page 56 of the bundle. So the bank would have been involved and would have sought to give instructions to the owners. Just in relation to that finding, I observe no finding as to whether those instructions would have been given directly to the owners or via Gulf, which of course was always owner's case. Owner's case was always that any communications would only have been between owners, between the bank and Gulf and the owners.
Does that matter?
Well,
if it's intended to be communicated to the owners?
Well, there's
as the bank's position?
Yes. Where it is relevant, but we'll come on to this in a moment, is in identifying whether the findings of fact are sufficient to find any sort of estoppel-based defence to the putative breach that would have taken place on the counterfactual analysis. And part of that analysis must involve a precise identification of who would have said what to whom and when, and how the other party would have reacted to those instructions, whether they would have acted on them at all, and or whether they would have acted in reliance on them.
All right, so it's paragraph 61.
Yes.
Bank would have given instructions to the owners.
Well, would have sought to give instructions.
Sought to give instructions.
Sought to give instructions to the owners.
Right.
Bearing in mind that it was the owner's case that we weren't entitled to give them any instructions. It was the owner's case that because BP was the lawful holder, it was only BP that were entitled to give any instructions. And there's no finding, as I say, as to whether any of those, any instructions that might have been given would have been acted on by the owners or relied on by the owners in circumstances, of course, where you have the owner's own evidence that they rely on the LOI that is provided, in this case provided by Gulf. And then...
I'm afraid I don't follow that. The counterfactual hypothetical is that the owners are refusing to discharge without the original bills and have asked who the holder is, have been referred by BP to the bank as the people who they've agreed to endorse it to, so you'll have to get the answer from the bank, and the bank are giving the instructions. The fact that in the absence of all that, they relied on the LOI is neither here nor there.
Well,
The hypothesis, the counterfactual, proceeds on the hypothesis that they wouldn't just rely on the LOI without the bank's specific consent.
well, this is the difficulty of trying to find out what the legal analysis is in the absence of any legal analysis and in the absence of any full findings of fact. Because one possible analysis is that Gulf say you are legally obliged to discharge pursuant to 3007, and you have your LOI. Get on and do it. And in those circumstances, if the unit at that stage comply with their charter party obligation to discharge, then there's no reliance on anything said and done by the bank.
Well, I understand that, but the counterfactual hypothesis we're assuming is no breach, i.e.
Well, no,
they're insisting on production of the original bills of lading unless they get the consent of the holder.
well, no initial breach, and there's a discussion, but there's no findings as to how it may well be. It's just as plausible as reliance on anything said by the bank that having had it firmly pointed out to them that they're contractually obliged to discharge pursuant to 30.7 in reliance on the LOI, they then do that. I mean, your lordship is introducing a finding that's into the judgment on the counterfactual that after an initial refusal to discharge, to breach the contract, they persist in that refusal unless there is something amounting to a representation by the bank that it will at no stage in the future sue on bill of lading contract if it becomes a lawful holder in due course. Now that's what would be necessary as a set of counterfactual findings, at the very least, to justify any finding that we have no claim.
I'm a little bit confused here. No, because paragraph 6, you're criticising the judge, whereas at paragraph 61, what she's saying is, in my view, the key point for this purpose is on the bank's case, BP was the lawful holder of the bill at the time, yet the claimant nevertheless accepts that it's reasonable to assume that the bank would have been involved and would have sought to give instructions. That's all she's saying. She's saying, actually, you accept that it's reasonable to assume that the bank would have been involved. So at that stage, she's not making any finding, and she's going ahead on the basis of what has already been accepted. That's all.
Yes, this is where we go back to the debate that we had yesterday in relation to the different purposes of a counterfactual in relation to quantum and a counterfactual in relation to causation, where in our submission the judge has impermissibly conflated two different concepts. We had a debate yesterday. With Lord Justice Popplewell as to is the if the same in the two counterfactual. And the initial if is the same if there is no initial breach. In my submission, what is important to remember is the different purposes of the two counterfactual analyses. What we were doing was seeking to identify the question that we were addressing was, what is the value of performance to us? What on a compensatory principle, what damages are required to put us into the position that we would have been in if the contract had been performed? That requires a valuing performance. Now, that obviously any counterfactual is hypothetical in one sense, but in terms of valuing performance, assessing what damages are payable for the compensatory principle, it's not necessary to consider a counterfactual that was ever in reality going to happen. it's if you like, almost a fictional assessment of what would have happened if there had been no breach, even though, on everybody's analysis, breach was inevitable, because the owners always discharge in reliance on the LOI. And so it's almost if you're like in a looking glass world for the purposes of valuing the value of performance. That the question that is being asked at the causation stage is an entirely separate question.
So it's the same counterfactual, but the difference between the two is that in one case it has to be realistic. You say it wasn't, whereas in the other it doesn't.
Yes.
That's the distinction you're drawing. Both require the court to put itself in the position as if the contract had been performed.
Yes.
But you say for quantum purposes, the critical distinction is that can be an unrealistic counterfactual.
Yes.
Whereas for causation purposes, it can't be.
It can. The reason why it can't, my lord, is because the question that one is asking at the causation stage is not what is the value of performance. It is the breach, which undoubtedly occurred, an effective cause of the loss. And it is illegitimate to say that the breach which occurred was not an effective cause of the loss by reference to a looking glass hypothetical, which would never have happened in the real world. There's nothing through the looking glass that can reduce or denude the breach itself of the causative potency that establishes it as an effective cause of the loss. And what the judge has done is to fail to appreciate the difference between the two quite different exercises that give rise to a counterfactual analysis. And that, I haven't got my notes from yesterday in front of me. I can't remember which of my numbered points it was, but that was certainly one of the points that I made. On the facts of this case, the entirely unrealistic counterfactual is not an available way of coming to the conclusion that the breach, which did occur, and which in a very real sense was obviously the cause of the loss, because if there's no breach, the cargo stays on the vessel. That counterfactual is not an available counterfactual for purposes of saying the breach was not an effective cause of the loss. But then what we also say is that even if it were, so this is now an alternative submission, even if it were a legitimate approach, the judge has not the judge hasn't carried out any legal analysis and has not made sufficient findings of fact that could possibly justify a finding that the breach was not an effective cause of the loss. As I say, even if it's permissible to enter this counterfactual analysis. What she seems to have done is made her findings, well, I take your ladyship's point that it's not even couched as a finding of fact, it's as an acceptance of part of our case. But in my submission...
Well, that's her starting point.
Yes.
Her starting point is that it's your case that it's reasonable to assume that the bank would have been involved. That's the first question, i.e., although BP was the holder, it was going to depend on what the bank said, and two, that the bank would have sought to give instructions to the owners.
Yes.
So then the factual question for her is, what instructions would have been given to the owners?
Yes.
And that's what her findings are addressed to.
Well,
that's what they should have been addressed to.
Yes.
That's the only issue on the way that she's framed it.
Yes, and
to which they're relevant.
Exactly, and she hasn't framed it there, nor does she make any findings at the end. as to, for example, reliance, which obviously we say is a crucial matter. The mere giving of instructions is not sufficient to find any defence.
In circumstances where the counterfactual assumes that there has been an initial refusal to discharge without the comfort of instructions from the true bill of lading holder, or
yes.
which in this case comes from BP, but on the basis that the bank will have to give those instructions.
Yes, an initial refusal. So, for example, in the Air and Shelter, on the facts of the Air and Shelter, there was an initial refusal by the confirming bank to pay out onto the LC. It was pointed out that they were obliged to do so, and they then did so. So the fact that there is an initial refusal does not mean that in the counterfactual world they are going to, in all circumstances, refuse to do so. I mean, just debating this point, one has to remember that the bill was at BP and didn't emerge until August. So there is going to be some breach by the owners in the counterfactual. The question
Why?
is, well, unless the judge hasn't found that the cargo is going to sit there until August.
But there won't be a breach in the counterfactual if BP gives its express consent.
No, there will be a breach. The discharge without presentation is still breach.
Really?
There may be a defence to the claim for breach on the basis that BP is stopped from.
Is it a estoppel, or is it? Why isn't it a variation of the contract?
Well,
the bill of lading is a contract with whoever the lawful holder is.
yes.
In your case, the owners say that in the absence of any communication, it would be a breach to discharge other than in accordance, other than with presentation of the bill of lading. The owner says, can I discharge without production of the bill of lading, which is why in the counterfactual it's not discharging.
Yeah.
And BP says yes. Why is that not a variation of the contract?
Well, if you have a series of exchanges between the carrier and the then lawful holder that amount to a variation, then I accept that hypothesize there's no breach of the contract as varied.
But isn't that exactly what's being investigated in the counterfactual? You accept that it's reasonable to assume bank would have been involved through BP, notwithstanding that BP was the holder, and would have sought to give the instructions with the agreement of BP.
Well, the bank certainly can't. The bank certainly can't agree to a variation of the bill of lading contract.
No, BP can, and BP. The whole point about what's recorded at paragraph 61 is that it's your acceptance that although it is BP who are the holder, it's reasonable to assume that it's the bank who would be making the decisions for BP, which is, if I may say so, perfectly obvious. I'm not suggesting it was a wrong concession, because BP had no interest themselves, but had agreed to endorse the bill to the bank and would have done so but for COVID. So one can entirely understand that they would have said, you'll have to ask the bank and we're happy as long as they're happy.
Yes.
I'm not suggesting that what you've submitted here is anything other than very sensible, but it was the starting point for the counterfactual that the judge was then having to make findings on as to what the owners, what the bank would have done.
Yes, it wasn't our case, wasn't anybody's case, that there would have been an agreement to vary the charter, to vary the bill of lading contract.
Well, it may not have been put in legal terms, but it was the case that the bank would have been asked whether they agreed, and the bank would have sought to give instructions as to whether it could happen. Now, it may be a matter of legal analysis as to whether you call that estoppel or variation. It looks pretty much like a variation to me.
Well, but it it wasn't any
Express request for agreement given.
But it wasn't anybody's case that is what would have happened. It was our case, again, purely for the purposes of the quantum hypothetical, that it would have, we would not have even suggested an immediate discharge.
Quite, but your witnesses were disbelieved on that. So that was on the factual point that failed.
Well, I mean, I mean, it was a different case that was being put to them. I see what your lordship says. But in my submission, the findings that are made, such as they are, do not go remotely go so far as to justify a variation analysis, nor any waiver analysis, nor any estoppel-based analysis. What the judge seems to have done is considered that the findings of fact that she made were sufficient to amount to defence in causation, without providing any legal framework for that, and without having made sufficient findings of fact that would justify any legal analysis.
Thank you.
I mean, one has to remember as well, of course, that our counterfactual was, for the purposes of quantum, was all based on what non-breaching owners would do, when the facts are that these owners always discharge against an LOI and are happy to do so. And that's not a criticism in this context of the owners, because that's simply the structure of the charter party and the bill of lading taken together. I mean, I invite the court to remember the context, and in particular the paragraphs in Aikens at 5.48 to 5.49, which I think I took you to in opening. It's page 298 of the authorities bundle.
Difficult to establish consent because there won't usually be communication directly with the owners, or communication with the owners. And that's the gist of it.
Well, that's part of it, but of course the communication has got to be not merely we want you to discharge. It's got to be we direct you to discharge in such a way that we are giving up our right to sue you for breach.
Yes. In the context of the hypothetical, which is that the owners have said we can't discharge otherwise than against the bills of lading. Whether they say it expressly or impliedly, we would understand that being because otherwise we'd be liable to be sued.
Well, again, in the context of an initial breach, and in the context of they're being contractually obliged to do so, and in the context of these owners saying that they rely on the LOI. As I say, the judge seems to have proceeded on the basis that those factual findings are sufficient to lead to a conclusion that our claim fails, without certainly any part of the analysis having identified that there is still going to, subject to your lordship's variation point, there is still going to be a breach, there's still going to be delivery without production of the bill of lading. And Akins, as I've said, discusses the difficulties in any circumstances of an acquiescence or estoppel-based defence being made out. That is in the context of an acquiescence or estoppel defence being made out against somebody who is the lawful holder and is entitled to give directions as to on the building contract. A fortiori, it must be very difficult to establish all the necessary elements of an acquiescence or estoppel-based defence against somebody who is not the lawful holder, which is the position that the bank was in at the time. And again, in my submission, it is important to have in mind the owner's case, which was that the bank simply was not in a position to give any instructions in relation to discharge. So if one looks at the owner's opening in the second supplemental bundle at page 445,
You say 455?
no, 445. This was their case in causation. We see what they said, particularly over the page 1413. So the claimant was not, at the time of discharge of the finance cargo, the lawful holder of the bill of lading, or otherwise entitled to give any instructions to the defendant, whether under the bill of lading or the charter party. Given that that was the owner's case, it's not a promising foundation for an argument that they would have accepted instructions from the bank at all.
So are you suggesting, for example, that if there was an initial refusal in the counterfactual, an initial refusal to discharge without a bill of lading, and then inquiries were made, and it was determined that the bank didn't hold the bill of lading, then, for example, it's just as possible that the owners would have fallen back on 30.7?
Yes. I mean, there's a world of possibilities. I mean, obviously, we say a looking glass world of possibilities because none of this would ever have happened in the real world. But the findings that are made are not sufficient to amount to. If one thinks about
that's contrary to what your recorder was accepting as what it was reasonable to assume.
But that's purely for the purposes of the. That's where we come to what's the.
That's your quantum stroke
Yes.
causation point.
Yes. Yeah. It's a notional or fictional exercise to value performance. I mean, we were. It was no part of that quantum analysis that these events were of any realistic possibility of actually happening in the real world in such a way as to remove the causative potency from the breach that had actually happened, so as to make it not an effective cause. Again, I've emphasised the importance of reliance. There are no findings as in relation to reliance at all. The only evidence that we have in relation his evidence that the bank relies on the LOI.
But not in the counterfactual.
Well, I mean, I'm going to say what I said again, which is that not on the first breach, not in relation to the initial refusal to breach, but one cannot, from that, even in this counterfactual world, infer that their attitude would not have changed. I mean, the fact that that is the bank's usual approach doesn't, in my submission, alter once you go through the door into the counterfactual.
But say would not have changed. Do you mean that in the counterfactual in which the agreement of the bank was going to be sought, and the agreement of the bank was given, it's feasible to think that they might not have relied on that at all. And since the judge hasn't made any findings, one can't assume, even though they've initially refused, because they want the consent of the bill of lading holder, it isn't a given that when they get that consent they would be relying on it if they then discharged without production of the bill. Is that what it amounts to?
Well, there are no findings at all as to what they...
Yeah, there are no findings, and it's not reasonable to assume, in the absence of findings, that that's obviously what they would have done if they'd asked for it.
Well,
if they'd asked for the agreement of the lawful bill of lading holder, and they were going to get it, you shouldn't assume that they would have relied on it when they got it.
Well,
you need a finding to that effect.
There's no finding that they would have asked for the permission of the lawful bill of lading holder. There isn't even that finding. And again, one has to remember that the way in which the owners put their case was that the bank would have simply have insisted on Gulf exercising its charter party rights. So, I mean, the cross-examination of Ms. Benaya was very much on what the bank would have said to Gulf. Cross-examination of Ms. Benaya didn't involve any communication between the bank and owners at all. If there is simply an initial refusal by the owners to deliver, and then the bank leans on Gulf to get Gulf to persuade the owners to deliver without production. In my submission, there's nothing there that could possibly tick all the boxes that are required for a finding of, as I say, an estoppel, which essentially is going to be an estoppel preventing the bank from bringing suit when, at some date in the future, it obtains rights of suit on the transfer of the bill of lading.
When you talk about the bank leaning on Gulf, you're meaning, I assume, leaning on Gulf to exercise its rights under the charter.
Under the charter party, yes. Again, if one looks at what their case was at paragraph 143 on page 446.
I'm sorry, I've lost you.
I'm so sorry.
446 of...
So we're in the supplemental bundle,
Yeah.
second volume. It's tab 87. And this is the defendant's skeleton argument for trial.
Yes, that's where we were.
And they say, also be considered what would have happened had the defendant advised Gulf that a bill of lading had to be produced for discharge to take place. The actual facts make clear that in that situation, the claimant would have instructed Gulf to insist that the financed cargo be discharged without production of the bill of lading, given that it had already authorised and approved that to be done. And so, given that that's the owner's case, if that is what is meant by the Gulf permitting discharge without production of the bill of lading, that sequence of events couldn't possibly give rise to an estoppel against the bank. What I would like to do next is simply make clear that at the trial, contrary to what our friend suggested earlier, we did not accept that mere consent in some way to the discharge without production could be sufficient to give rise to a causation defence. It's necessary to look at a number of references in relation to this. We look at page 526 in the second supplemental bundle. Just to put this in context, the hearing was 4 days. We had, I think, 3.5 days of evidence, and then submissions which covered all the issues, including the ones that are before you and the numerous issues that the judge didn't decide. Submissions were telescoped into a single day. Single day.
Sounds like you didn't have long enough.
Do we ever? Essentially, we both took the view that we'd said what we wanted to say about the law well, not entirely. We obviously relied on the opening skeletons for a lot of the material, and there was discussion of the evidence. And in this part of the closing submissions, I was addressing Miss Bodnaya's evidence, and her evidence was that she wouldn't have agreed to discharge by STS at Sohar, and I was submitting to the judge that evidence should be accepted, and that the acceptance of that evidence was a necessary element in any causation defence. Now the transcript says the necessary element. I don't know whether I said the necessary element or a necessary element. It makes no difference. What we were saying was that the factual finding is self-evidently a necessary element of any causation defence, and that finding should not be made.
Well, it's a critical difference on the way it's being put at the moment. If you either said or merely meant A, in the sense that it's a step but it's not sufficient, that's one thing. If you said and meant the, i.e. the causation defence depends on this, then that's quite different.
Well,
I quite understand that one must be very cautious about whether what you actually said was A or D, because these things often aren't picked up and aren't corrected. But there is a difference between A and D.
Well, Lord, not of great significance. It was still the necessary factual finding. I certainly, it must have been, on any fair reading of that, it certainly wasn't my intention to say that the factual finding is sufficient to justify a causation defence. Yeah. And one sees that as Lady Justice Falk pointed out earlier from our closing note at page 478 in the same bundle. we certainly we're not accepting the only issue in relation to a causation defence was an absence of a factual finding.
But I understand your submission that you say you didn't actually concede that consent gives rise to a causation defence, to say hypothetical consent, if we're talking about causation, or actual consent if one's talking about actual breach. But whether or not you did concede it, why is it not right that if the lawful bill of lading holder gives consent, that's an answer to a claim for breach, whether you frame it as estoppel or variation or waiver?
Well, the short answer to that is because consent it isn't a defence. It may be a shorthand for a waiver by estoppel or an equitable forbearance type argument. But what you have to do is identify all the necessary elements of such a defence.
Consent means agreement. So if agreement is sought and given, then whether you put it as a variation or a waiver or estoppel, you're going to have fulfilled all the ingredients, aren't you?
Well, if there is an express agreement between the carrier and the at this stage not yet bill of lading holder, but somebody who might become a bill of lading holder.
No, I'm positing it's with the bill of lading holder.
I'm sorry.
I'm positing that it is with the bill of lading holder.
Yes.
But that in the factual circumstances of this case, that person's consent would be dependent on the consent of the bank.
Yes.
Because of a particular circumstance.
But it depends what is meant by consent and how consent is communicated to the carrier, if it's communicated at all, and then whether the carrier relies on that consent or relies on something else. The textbooks and the authorities suggest that the fact that the bill of lading holder knows and expects and anticipates that the cargo will be discharged will be delivered without production of the bill of lading. So in that sense, consent is not sufficient to give rise to a defence.
No, we're talking about consent which is sought from and communicated to the owners.
Well, I'm afraid I'm going to give the same answers I gave yesterday, which is sorry, I don't mean to.
No, but what I'm concerned to understand is that I quite understand all your submissions on the facts of this case and the lack of findings by the judge.
Yes.
But I was just trying to understand to what extent, I had thought, and I think you did concede initially when I put it to you, that if you had the consent of the lawful holder, that would prevent breach. And now you're rowing back from that a little bit. And I'm trying to understand what are the circumstances or what are the qualifications where the facts are, may not be this case, but where the facts are, owners say won't discharge without production of the bills. Please, lawful holder, will you consent to me doing so? Lawful holder says yes, we consent to you doing so. Take that as the simple facts. Not consent in the sense of being content with that, yes, without any communication with anyone.
Yes. But
consent in those terms.
Well, I think the discussion we had yesterday was my not accepting that consent in broad terms was sufficient. Your Lordship saying, well, but what if the carrier said to the lawful holder specifically, do you authorise me to discharge? And what you have to have is the factual building blocks to establish either a contractual variation or a waiver by estoppel or an equitable forbearance of some sort. And it's always going to be fact specific. You have to look at the constituent elements of each of the possible ways in which consent, in a broad sense, could amount to a defence, and and see whether each of those constituent elements have been established on the facts or not. So,
And what you're saying is here, none of that was done. Nobody considered whether there was a clear representation which was relied upon, for example, etc., etc.
well, that's absolutely right. I mean, one can see in the decided cases, not much of this context, in many cases, in all sorts of different contexts, where forbearance defences or waiver defences are done. There is a painstaking analysis of the fact in relation to what the representations were and whether there was any reliance. Now, here we're not even dealing with established facts. We're dealing with a hypothetical situation, and a situation where there is no proper finding of these hypothetical facts. And I'm going to say it one more time, and then I'll try not to say it again after that. In what we say is an entirely impermissible exercise in any event, because it's an entirely unrealistic counterfactual that would never have happened, and therefore cannot denude the breach of its cause of potency. So, as I say, the submission that is made by my learned friend that consent is a defence is far too simplistic a statement. And again, another way in which it was put by my learned friend was to say, well, the judge just did what she was being asked to do. We can't complain about that. That again ties into the point I've just made, which is that the exercise that we were inviting the judge to do was for an entirely different purpose and to answer an entirely different question. How is performance to be valued for the purposes of the compensatory principle on the one hand, as opposed to, are there reasons to hold that the breach that took place, and which prima facie was the immediate and proximate cause of the loss, was not an effective cause of the loss at all. But if I might just have one moment. It's perhaps just worth drawing the court's attention to this paragraph in the respondent's. See where we are. It's the respondent's skeleton argument for the trial. So, bundle 2, page 87, tab 87, page 455. I'm not going to take you back to the owner's amended defence, which we've looked at several times now, but you'll remember that in their amended defence, that they have a single line at the very end saying that the bank has put to proof that it wouldn't have happened in any event. None of this counterfactual is posited in the defendant's defence, the owner's defence. What they said in relation to our quantum counterfactual at 178 is that it must be dismissed at the outset because the claimant has failed to identify any basis upon which it says it would have obtained the requisite knowledge so as to intervene to prevent the delivery of the financed cargo from the vessel. Now, it's another way of saying that the entire exercise is an entirely unrealistic one. We say it's legitimate for it to be unrealistic for the purposes of quantum, but not legitimate. The unreality of it makes it illegitimate for the purposes of the causation inquiry. And again, the causation inquiry is there any sufficient reason to hold that the breach was not an effective cause of loss? Right. Unless I can assist further in relation to that ground, I'll move on to the...
Thank you. Please do move on. You're going to ground one.
Yes, ground one. And it might be useful just to step back and consider the effect of the novation on the relationship between the shipper and the carrier. So the question is whether, when the charter party is, well, one of the questions is whether when the charter party is there a contract in place between the BP as shipper and the owners as building carrier. So from the 6th of February, which is the date of the charter party, BP and the owners are in the relationship of charter/owner. From the 19th of February, when the cargo is put on board and the bill of lading is issued, they are additionally in the relationship of shipper and carrier. On the 3rd of April, when the charter party is novated, they bring their relationship of charterer and owner to an end, at least in terms of prospective rights and obligations. But fairly obviously, that they don't bring to an end their relationship of shipper and carrier. When they entered the charter party on the 6th of February, they entered into a contract, and obviously the charter party contains a set of contractual terms. When the bill of lading is issued, the bill of lading undoubtedly contains a set of contractual terms as well. And it's common ground, at least, that it has the potential to become a contractual document, and would have become a contractual document if it had been endorsed and delivered by BP before the novation on the 3rd of April. So if it had been transferred to the bank before the 3rd of April, it's common ground that it would then have become a fully fledged contractual document.
Or indeed after, provided it was before the end of the voyage.
Yes. And the question really, therefore, is what set of terms, if any, did the parties intend, or are they taken to have intended, to govern their relationships at different points in time? We say that it's common ground that from the 6th to the 19th, was obviously common ground, from the 6th to the 19th of February, it was the charter party that governed the relationship. The only relationship being in play at that stage, the charter-owner relationship. From the 19th to the 3rd of April, there are now two sets of terms in play. But although the bill of lading has at least the potential to become a contract of carriage between carrier and the bill of lading holder, again, it's common ground that both sets of relationships for that period of time are governed by the bill of lading terms. And that reflects obviously what's called the mere receipt.
The charter
Charter
party.
party.
Charter party, I beg your pardon. That's quite an impressive chorus. So yes, of course, it's the charter party that governs both sets of relationships, and that reflects the mere receipt rule. The bill of lading is for that period of time is treated as a mere receipt. And as we said yesterday, we say that's really a question of construing the two sets of terms together. We see the reference to it being a question of construction in the Rodokanachi case, and I took you through the relevant passages yesterday. Obviously, the critical time period is from the 3rd of April onwards. I apologise, I've laboured the analysis up to the 3rd of April. From the 3rd of April, in relation to rights and obligations arising out of the charter party relationship, which had arisen prior to that date, they continue to be governed by the charter party. See clause 1.1 of the novation agreement. In relation to rights and obligations arising out of the shipper-carrier relationship between BP and Euronav, which had arisen prior to that date, there might be more scope for argument as to whether it would be the charter party or bill of lading terms. This was a discussion that I had with Lord Justice Popplewell yesterday. It's prima facie, it seems likely that Your Lordship's analysis is right, that it would still be the charter party that would govern the rights and liabilities arising out of the shipper-carrier relationship between BP and Euronav prior to the novation. Just pausing there, it's obviously right to note that on any view, it's not the entire contractual relationship between BP and owners that's coming to an end on the novation, because some of the charter party obligations continue. And so it's a mistake, I think, to say that the judge does at paragraph 47 that all contractual relationships are being terminated. But in any event, the relationship of shipper and carrier remains in place. So regardless of the extent to which contractual relationships are being brought to an end, the relationship of shipper and carrier remains in place. The owners still have the cargo which BP shipped on board the vessel. And really the issue is whether the parties are to be taken to have intended that that ongoing relationship should be governed by a set of contractual terms or none. And for the reasons that we've given, we say it would be entirely unrealistic for shippers or carriers to wish to proceed on the basis of a non-contractual relationship. And that must be the presumed intention, because it must be the presumed intention that the bill would govern in these circumstances, because otherwise owners would be exposed to claims for which they would not be able to rely on contractual terms as a defence. And indeed, it's a striking feature, we say, that in most of the more mere receipt cases, it's actually the carrier who is seeking to rely on the bill of lading terms, because the bill of lading terms are often more favourable to the carrier than the charter party terms. And that's often the case in the pre-Hague rules regime cases. Now, of course, it's the carrier who would want to be able to rely on the bill of lading as a contractual document, because that brings in the rules and their exceptions and so forth. And a fortiori, we say, where the set of contractual terms have already been issued to BP, the carrier has already issued the bill of lading to BP, it is easy, we say, the only answer to presume that the intention of the parties was that their ongoing relationship of carrier and shipper should be governed by the set of contractual terms set out in the bill of lading, which is the document that universally governs that relationship, save where the mere receipt rule applies.
And what do you say about Mr. Thomas's argument that actually there will be no contract, but there will be a bailment on the terms of the charter party?
Well, I don't accept that any ongoing bailment would be on the terms of the charter party in circumstances where the charter party is novated and is no longer extant. And one can see that from the terms of the novation. In my submission, that would be right as a matter of general principle anyway. But in the novation, if one has that again in the supplemental bundle, first volume, tab 24, page 83, clause 1.1 says, without prejudice to accrued rights, the current charterer shall cease for all purposes to be a party to the charter party. In my submission, it is inconsistent with that to say that there is an ongoing bailment relationship on the terms of the charter party. The presumed intention must be, in my submission, that the parties' presumed intention is that the bill would govern their shipper charter relationship after BP ceased to be a charterer. And really, the choice is on our case a binary between being the charter party terms up to the date of novation and then the bill of lading terms thereafter, or owner's case a binary between charter party terms up to the date of novation and then no contractual terms at all thereafter. And for all the reasons that we've outlined, that is. Cannot be the presumed intention of the parties, notwithstanding the issue of bill of lading, a set of contractual terms being in place, which universally governs relationship between shipper and carrier, unless the mere receipt rule applies, with another contractual framework. These parties are to be presumed to have intended that there should be an entirely uncontractual bailment and shipper-carrier relationship. We set out the anomalies, I think it's paragraph 35 of our skeleton. My friend says those aren't significant. But they are significant because the question is, can it be presumed that the parties would have intended for those anomalous and highly uncommercial consequences to follow, as they would follow if there is a non-contractual relationship? And we say that that cannot be presumed. So that's what I wanted to say in relation to that aspect of the case. What I'd like to touch on briefly now is our two contracts in parallel argument. I want to make it clear that we don't resile from the submission at all that a new contract appears to spring up, whether it be on endorsement or novation or whatever else. The language in Hain and Tate and Lyle is of a new contract appearing to spring up. And clearly that is understandable language in circumstances where before the bill of lading terms didn't have contractual force, but then they do. One can see why the metaphor of springing up is used. What we are seeking to do is consider two alternative underlying rationales for the principle that the new contract appears to spring up. Is it simply a legal device for which there's no satisfactory principled explanation? See Carver and Scruton and Benjamin, I think, is the other book that cannibalise each other to a certain extent. Or is there a more principled explanation? And so all we're seeking to do, by way of our two contracts analysis, is to provide the court what we say is a more principled explanation. It's not a necessary part of our case, because we say that it doesn't matter what the principle by which the new contract springs up. It springs up just as much on novation as it does on endorsement.
I floated, I think, earlier, whether a third rationale would be conventional offer and acceptance. That the ship owner, by issuing the bill, makes an offer which is capable of being accepted by an endorsee by taking an endorsement. I certainly have in the back of my mind that may have been in analysis in the Brant and Liverpool cases, so on, in which there was said to be a contract merely from presentation of the bill. But I don't immediately see why there would be a communication of acceptance problem. There's another way. Obviously, there would be no communication of acceptance, but we know we can have contracts which are capable of being accepted by being acted on, when one acts on an offer, and it could be an offer of that nature.
Yes.
But I put that out because I can't believe it's not something that hasn't been given some thought by the commentators. If Mr. Foxton's, I think he still then didn't think there was anything in it, I'd be interested to know why.
Well, I suspect that the reality is that if one looks at the textbook commentators, they simply accept that none of the authorities have set out a principled rationale, and say, well, maybe the best explanation is that it is simply a legal device. I do feel that some of the criticism in the judgment of our approach is a little unfair in circumstances where we were attempting to provide a principled analysis. It was not surprising that we couldn't point to an authority in support of it, because we were trying to do something that perhaps hasn't been done before. Again, before the judge, we were running the argument, which we don't pursue, which was that the bill was initially issued to a different BP entity, and so it would have had contractual force at the outset. And when it then passes into the hands of the charterer and then out of the hands of the charterer again, that sort of factual scenario perhaps leads more strongly or supports the two contract analysis. That it's undoubtedly a contract when issued to the non-charterer. You then have a period where the two contracts are in parallel, but the bill of lading contract is dormant or suppressed, or however one wants to put it. But then revives or comes back, comes awake again when it is either endorsed by the charter to another third party, or the charter party is novated. Lord Justice Popplewell, I think during the course of my friend's argument, raised the question of why would the sale contract contain a provision in relation to novation? I don't know what the answer is to that in this case is, from the perspective of the parties themselves. One can see that in relation to a cargo which, for whatever reason, may be on board the vessel for a considerable time, the buyer would have an interest in acquiring the rights of a charterer, so he can give directions to the owners as charterer. And so one can can see why there may well be a commercial interest on the part of the charter in having the right to take innovation of the charter party. Conversely, that there may be an interest in the seller, because he wants to be able to divest himself of his obligations to the owner under the charter party. One can see why there might be a commercial rationale for that.
But that would probably be only arise at a time at which the seller had ceased to have any commercial interest in the voyage because they'd been paid and past title.
Yes.
It's difficult to think that the seller would be content to abandon
Quite so.
charter party rights whilst he still had an interest in the performance of the voyage.
Quite so, but if the seller under the sale contract anticipates that there may be a delay in his resale, one can see why both parties in that situation. So when there is a prospect of the cargo being on board for a considerable period of time after the seller/original seller has divested himself of his interest in the cargo, why the parties might both wish to transfer the charter party rights to the buyer, so that the buyer who now has an interest in the goods has control of the charter party rights, and
especially in relation to arrangements at discharge, which otherwise have to go through
the charter.
Through the
yes, exactly.
charterer.
Exactly, quite so.
And that rationale may derive some support from the fact that this clause in the sale contract provides that if they can't get innovation, BP are to agree with all the discharge instructions which are given by Gulf.
Yes, exactly. It's putting the party that has an interest in the cargo in charge.
Right, thank you.
Because obviously, we've talked about the relationship between the shipper and carrier, or bill of lading holder and carrier. The basket of rights that the bill of lading holder has is very different from the basket of rights that charterer has. Perhaps less difference in the context of voyage charter, obviously, than it would be in time charter, but nonetheless, there are additional rights that the voyage charterer has, which the bill of lading holder doesn't have.
And this wasn't a case where the bill purported to incorporate charter party terms, as it sometimes does.
I'm pretty sure that's right. I'm told it is right. Again, unless I can assist the court with that part of things, I'm going to look at COGSA very briefly before leaving ground one. That's what I wanted to say in relation to that part of the case. The COGSA argument, we say it is covered by the first three grounds of appeal. It's set out in the skeleton argument. It was obviously, which was the skeleton you've got in the bundle is the appeal skeleton rather than the permission skeleton, but there's no change to that part of the skeleton argument. So the COGSA argument was made at the permission stage. And there's no suggestion in the order of Lord Justice Mayles that he wasn't given permission for any arguments that weren't in the skeleton argument.
It wasn't made to the judge, and it wasn't included in the issues that the judge was asked to decide, was it?
It certainly wasn't made in the same way in which I make it now. No.
Well, at all, issue one was phrased by reference to whether it was a contract of carriage at the time of discharge.
Yes, but then as I think I showed the court yesterday, there was a later issue relating to
whether the bills were spent.
To COGSA, yes. Well, it was simply put whether the bank became lawful holder of the bill pursuant to Section 2 on the 13th of August. So, I mean, one could argue...
But that wasn't put forward as something on your side which you could succeed on if you failed on issue one.
Exactly, wasn't. That's not a reason for the court not to deal with it now, because it is, as Roger said, a the point I principally wanted to address is the question of retrospectivity and whether misdelivery is different. And the thrust of Malone and Friends' argument was how can there be liability for misdelivery if at the time of delivery the only extant delivery obligation was to deliver in accordance with the terms of the charter party. But as Lord Justice Popplewell said, the retrospectivity principle applies across the board when there is an endorsement of the bill of lading. Lord gave the example of a breach of Article 3.2. One could apply it equally to a breach of Article 3.1, so the obligation for at the beginning of the voyage to exercise due diligence to make the vessel seaworthy. If there is a transfer of the bill during the voyage, or even after delivery, the carrier will be liable for a failure to exercise due diligence before at the beginning of the voyage to make the vessel seaworthy. So you have that obligation didn't exist at the time because there was no bill of lading contract on this hypothesis at the time. But the carrier becomes liable for a breach of it weeks, months, whatever it is later. And the liability regime in the charter party, it may well be very different indeed from the liability regime under the bill of lading contract. One has to think of the very narrow owner's responsibility clause in the GenCon form, for example. So that the obligations upon which the carrier will eventually be sued simply do not exist at the time. But the carrier becomes liable for them in the event of a subsequent transfer of the bill. And in my submission, there is no reason why a misdelivery claim should be analysed in any different way. And if anything, one might say that the case is stronger for us in the case of misdelivery, because obviously all the authorities state that a carrier who has issued a bill of lading and who delivers without production of that bill of lading does so at his peril. And there are at least...
Because it's a breach of contract.
Because it's, yes, well, he does so at his peril because it is, he does not know whether he is breaching an extant contract, or we say, breaching a contract which may still come into force. But when the charterer gives discharge orders, at that point, regardless of the nuance in this case, at that point, the carrier does not know whether somebody else holds the bill of lading, and so whether there is or whether there is not a bill of lading contract. So one doesn't have to have any sympathy for the carrier. He's issued a bill of lading, and he knows that he may be liable upon that if it is transferred to a third-party transferee. And there's no qualitative difference in the retrospectivity, we say, between misdelivery breach and any other breach. There was an argument below as to whether the bill was spent or not. That's no longer, as I understand, a live argument. Just one nuance in relation to that. We've put the Aaron Schulte decision in the first instance decision in the bundles. if you were to look at that, it did go to appeal, and we haven't put the appeal decision in the bundles. One of the points on, so there was a concession made in the Erischulte that the bill was spent. In the Court of Appeal, Lord Moorbeek said that that concession had been wrongly made. So in fact, despite what the first instance decision, which you do have in your bundles, says, the Court of Appeal decision says that the fact that the cargo has been misdelivered does not cause the bill to be spent. That's consistent with what is said in Aikens. The references, authorities, page 317, paragraph 8.53.
Is it paragraph?
Paragraph 8.53.
Thank you.
And obviously, in relation to the COGS argument, we rely on the passage in Scratton that we've set out in our skeleton, that's referred to in our skeleton argument, which we taken to. That there has to be a reading, to give sense to COGS, there has to be a reading in of words. And that is what we rely on. So now, again, that's what I want to say in relation to our two grounds of appeal, unless there's anything else I can just think of those. Lady, unless there's anything in particular I can assist you with on the respondent's notice points, I didn't intend to address those.
No, thank you very much indeed, and thank you therefore. Thank you to everybody, both to you, Mr. Russell, and to you, Mr. Thomas, but also for everybody behind who's no doubt under a huge amount of work in this case. Thank you for your very interesting submissions on a difficult series of issues. We will reserve our judgments, and they will be dealt with in the usual way, and you're very familiar with that. A draft or drafts will be circulated to the people whose information has been provided. I must warn you to be particularly careful about not breaching the embargo. I'm sure you're very sensitive to that at the moment. And as usual, as you're also very aware, please don't try to re-argue the case, only correct our obvious errors and our spelling mistakes and maybe our syntax, possibly, maybe. But don't get too carried away. Those will be dealt with in the usual way. If you can't agree an order in relation to consequential matters, then you'll also know very well that we like you to put in short, and that's short, written submissions on that, and it will be dealt with on paper. Just thank you very much indeed for presenting a very, very interesting matter, and having done so within a very short span of time. Thank you.